afternoon, and we'll call Alamosa County Case 25 CR 128, People versus Barry Morphew. Ms. Kelly and Mr. Johnson are present virtually on behalf of the state. Mr. Beller and Ms. Byrielson are present on behalf of Mr. Morphew. And I see that Mr. Morphew is with Ms. Byrielson. And we'll note that several of the victims are present on the line today, and counsel for the Mormon victims are present on the line as well. Right. This matter was set today for a status conference, as it were. We were set for motions July 6th through 11th, and for trial October 13th through 20th. However, Mr. Morphew has filed a motion to continue. Ms. Byrielson or Mr. Beller, I don't know if you have anything else you would like to add with regard to your motion to continue.
Good afternoon, Your Honor. Ms. Byrielson is going to be addressing this. I did want to note for the court's information, however, it does appear from my end that Macy Morphew is on, and also Mallory Morphew are also on.
Yes, they are.
Okay, thank you.
Ms. Byrielson, go ahead.
Can you hear me?
Yes.
We don't have anything to add outside of what we have put in the filings. If Your Honor has any questions, I'm happy to answer them. I would also note that in our motion we did request that if there are things that you would like to ask about that touch on attorney work product, that's something that we would be willing to discuss with you ex parte.
Sure. Ms. Byrielson, my question is more so, why are you asking to continue the motions here?
Yeah, I think that the part of the motions here, we can do the motions that do not need calling of witnesses, but we do not feel, as we stated in our motion, that we have a good enough grasp and a good enough organization of the mountain of discovery we have to properly question witnesses that would be put on potentially by the people on the 807 motion specifically, and possibly the motions related to the 404 notes.
Okay. And my other question, because I'll just be frank, I am inclined still to go forward in July on the motions we can cover, because if we do have that amount of time allotted, I want to take care of what we can take care of when we can. That being said, several of those motions are things like requests for discovery, requests to exclude things that are already impermissible under the rules, and some motions in limine. Are you asking for a hearing on all of the motions that you filed? Just
yes, Your Honor.
Altogether. Okay, thank you. All right, Mr. Johnson or Ms. Kelly?
Thank you, Judge. I will largely rely on the written response that we filed. I'm sorry that we filed it this morning. I hope the court had a chance to review it. Judge, on behalf of the victims first, Mr. Grant would like to address on behalf of the victims' siblings. On behalf of the siblings, the people are objecting to a continuance, and I'll allow Mr. Grant to talk more about that. I do want to note that Mr. Morphew and Suzanne Morphew's daughters do not object to the motion to continue. Judge, I would like some guidance. Obviously, we object for the reasons that I put forward in the motion. I would like some guidance, however, if the court is going to proceed with July 6th, my position is that most of those motions that were filed can be ruled on paper, and I'm not sure if the court has an idea of what motions that the court needs more oral argument on. My view is similar to the court's, that most of them are motions in limine regarding evidence kind of in a vacuum, and I'm not sure it would be productive to have more discussion regarding those motions until we actually see what's been presented at trial. But Judge, I would largely rely on the response that I filed unless the court has any questions for me.
Thank you. Mr. Grant? I'll unmute you, Mr. Grant. There we go.
There
Okay,
we
go
go.
ahead, sir.
Am I off now?
Yes.
Off mute? That always helps, although sometimes people like it better if I'm on mute. But thanks for the opportunity to address the court on behalf of the victims' siblings, Melinda, Andrew, and David. As victims themselves, I think it's important for the court to hear their voice and for that to be heard. They're objecting really for a number of reasons. The most clear and obvious one just being that they live every day with the grief and the pain of missing their sister, and they're basically tormented thinking about what has happened to her, and they're just desperately needing some closure to this case. So that gets prolonged, obviously, as the trial gets pushed out. They've also made plans months in advance to attend the trial, including travel arrangements and booking places to stay and so forth, and they have indicated to me that they've done that already. They're also concerned that from their knowledge and what they know, that Mr. Morphew does present a flight risk, they wanted me to state that to the court, and that they feel that, I guess they're very scared about what would happen if he were to escape the jurisdiction of the court and not have to face consequences for this. And then finally, that they support the DA's position, have gone over the DA's reasons for objecting, and they would also stand behind that. So I would just ask you to please consider that any continuance of this just, again, prolongs the agony, and that would affect the victims in this case. And so they're asking the court to move forward as scheduled in October.
Ms. Byrielson, I do have another question that Mr. Grant just reminded me of. To the district attorney's point in their response, there is an almost unprecedented amount of discovery, and I am empathetic to how much time it is taking you, Mr. Beller, your assistants, to get through this. However, that is going to continue to happen. Fair to assume the prosecution has not ceased preparing or exploring its arguments for trial, and so ostensibly discovery will continue to come in. And so at what point do we say it's time to do this trial?
You're right. I think, not to be crass, but at the point that we're ready to render effective assistance of counsel, and our motion is based in large part on the bulk of discovery that was gotten originally. As the court knows, we got many, many terabytes originally, and working to organize that, catalog it, review it, cross-reference it with other things, and work with it has just been very, very, very time-consuming, and a task that has had some hurdles that, again, we could explain more to you as part of it, because it would involve a lot of work product and defense strategy information. But Your Honor, to answer your question, it will have an end. I think we are definitely progressing, but we do need more time. I think that's the fairest thing to say, but I do think that we are getting in a better position, but not one that gets us ready in October, but one that will get us ready, around May of next year would be the day we were listening.
Okay. Well, I would note it was set in October at counsel's request. So, despite the statement in Mr. Morphew's motion that it was the court's doing, it was Mr. Morphew's request in October. So, I would just note that when you say things like we think we'll be ready at X time, I'm going to take that to heart, that you are giving me your best estimates of that. So
I appreciate that, Your Honor, and I am trying very hard to do this.
Ms. Kelly, anything else with regard to this issue?
So, Judge, if the court is inclined to grant the continuance, we'd be asking for a trial date in January. I think given the fact that we're in June, that gives us more than 6 months. I think that would be sufficient. So that's what we're requesting, Judge.
Well, I am empathetic, as I said, to the unbelievable amount of information that all the parties, including the prosecution, are going through, and to the point of the victims in this case. None of us want to do this more than once. For sure, all of us want to do this in a way that this family only has to go through this one time. And so, to that end, I am going to grant the motion to continue the trial. And what I'm going to ask the parties to do is to talk amongst themselves and determine a trial date that is agreeable with the prosecution, with the defense, and that is workable for the victims with a start date prior to June 1st, 2027. So I'm going to give you that direction. We are still going to go forward on July the 6th. And I will send the parties an email with the motions that I expect to hear on July the 6th. I anticipate that it won't take all of the entire week that we had set out, but I will leave it set for the week in case that time is needed. And it'll be my expectation that parties show up on July the 6th with a proposed date to continue the trial.
Understood, Your Honor. Would it also be possible to ask your clerk if she is able to notify the parties of any unavailable dates that the court may have during that early sort of spring time frame?
Sure. I gave you the very general set of dates because I think at this point I'm pretty free. So if you call dibs a year in advance, you get a better chance of getting as much time from me as you need. But certainly we'll look at our calendar and Mrs. will let you know if there is any amount of time in there that I cannot do.
Okay, thank you, Your Honor.
Judge, can I ask for one slight modification?
Sure.
Scheduling wise, if we are going to go into May or June, would it be possible that we can explore July as well? We want to start sooner than that from a prosecution standpoint, but I have some obligations at home, like Little League basically goes through then, and I don't want to get stuck like right at the tail end of that if it's really close. Can we look at July as well?
I'm going to go with yes, but it's going to require an additional waiver by Mr. Morphew. Because right now his waiver goes through, I believe, January 31st or something along those lines. So.
And thank you, Judge. We're going to propose something earlier for defense. It's just if we get caught at the tail end of that, I just want to have a little more flexibility. So I appreciate it.
Sure. Discuss it and let me know if that's what works best for everyone, including the victims, then that's what we'll do.
Judge, one more point of clarification, just because it would involve some scheduling on my end. Does the court anticipate hearing testimony to support our offer of proof on 807 and 404?
No, neither of those are motions that I anticipate doing. I'll give you because there's 17 motions that I've identified that I think we can take care of during the July dates. None of them are motions that require testimony.
I appreciate that, Judge. Thank you.
Yes. Okay. Ms. Kelly, Mr. Johnson, anything else from the prosecution today?
I have nothing. Mr. Johnson?
No, Your Honor. Thank you.
Okay. Mr. Beller, Ms. Byrielson, anything else from the defense?
No, thank you very much, Your Honor.
Okay. Mr.
Thank you.
Vance, anything else on behalf of I'll refer to them as the sibling victims?
Nothing else, Your Honor. Thank you.
Okay. All right. Thank you all for your time this afternoon. I will see you all. We will begin promptly at 9 a.m. on July the 6th. Parties are required to be here in person on that date. And the same rules for media will apply. The same rules for observation will apply. on those dates. If you have any questions about those, please contact the clerk of the court, and she will gladly pass that information along.
Understood. Thank you, everyone, for your time.
Thank you.
Thank you.
Thank you, Judge.